for whatever reason the county chooses to articulate, that disruption is defined as. And that in the event that someone wants to exercise a seniority for a job assignment that has a locational component or shift selection, and the county says, I cannot allow this employee to bid on this shift because it's going to cause a disruption. Well, what's the disruption? Well, the disruption is that everybody hates him and he hates everybody. It's not going to be a cohesive work group. We simply can't put this employee into that group. Or, as an example, although he has the credentials to do the job, he has failed miserably, and here's his disciplinary record to justify why we can't put him in this position. We can't afford to have whatever job we're talking about screwed up because of the employee's past history of not performing well. Those are examples.
All right, now read it to me again, because I have it in front of me.
In cases when an employee's seniority cannot be considered because of operational reasons, the county shall articulate its justification for not recognizing seniority as a controlling factor. I still want to have the ability to say, you're wrong, and I want to see why I'm going to show you why you're wrong, or at least have the...
Including the right to appeal or agree.
Correct. And the only reason being is because otherwise, I even have it in there. It's just a simple matter of, if it's you say, or it's not going to be here, somebody makes a decision that I don't want to put this employee into that work group because A, they have failed miserably in the past, or B, they don't get along with everybody and nobody gets along with him. That is simply, if the employee disagrees with that, he may be 100% wrong, but at least he has the ability to say, this is wrong, I want to have a grievance and I want to discuss this matter. And then I fairly, as a business agent and a representative of the local union, will assess as to whether or not the grievance has any merit or not. And
so then,
sometimes it will, sometimes it won't.
The end result there would be, from your point of view, is that ultimately you could take that to arbitration.
Any grievance is subject to arbitration.
Somebody that flies in from Timbuktu, who doesn't know the operations of the county, could decide that their opinion about that management decision should control.
Jim,
You would want us to live with that?
The answer is any grievance that's subject to arbitration is the guy coming in from Timbuktu. So the bottom line is, all I can tell you is that 4 years ago, when we started doing this, or 5 years ago, however long it's been, you didn't know me, and I didn't know you, and the county didn't know me, and so on. And I, once again, am just hoping that I have earned somewhat of a reputation of being level-headed and being fair, and when we have a case, we proceed with it, and when we don't have a case, I graciously drop it, okay? And I think I've established that even with you, Barbara, that when there's situations that we are not in a correct posture, in a correct position, our position is not correct, even though the grievance telling me this, I will be the one to say that, listen, this grievance doesn't have merit, we need to move along. We haven't taken a single case to arbitration in all these years. We've been able to work things out that should be worked out, and we've been able to withdraw things that should be withdrawn. And all I can ask for is that you honor that commitment that we've made to being fair. I don't think this is that big of a thing. It's not going to answer half the problems that we have.
Somebody as reasonable as you might not be here or assigned to the county 6 months from now.
I plan on being around for a long time, trust me. The bottom line is you just take it out next time you're bargaining, go to impasse over. And if you have 15 examples of why you got screwed over by a local union, I would imagine that would hold some weight in your impasse sound. And where does impasse go anyway? It goes before the county commission, right? So you guys have the advantage of getting something removed from a contract if you really want to. We all know that. That's just the nature of collective bargaining in Florida in the public sector. And so all the messages, give us a chance. Give us a chance to just and if you don't believe anything that's not fair is going on, then...
But you have the chance now, John. In situations that are not subject to appeal or grievance right now, you still have the right to meet with Barbara and try to persuade her that your point of view is correct. You just don't have the formal structure of an appeal or grievance.
I've been told by Barbara very specifically, in a situation where there's contract provision and section 2 about things that are traditionally bid the seniority is a factor must be taken into consideration, and I don't have a right to grieve it, so I don't really even want to talk about it, and basically is what she was implying. Why are we even here? Why are we having an agreement? It's just, you can't grieve this,
It
John.
sounds like you talked about it.
And it didn't get, nothing got resolved, because she didn't want to even talk about it, she didn't want to hear about it. And my point is that, if we can't even get our foot in the door to discuss something and talk about something where it's just a bunch of nodding their head and smiling and say, okay, yeah, I hear your point, but you know what, you can't read this thing anyway, so, sorry, goodbye. That's not fair. I just don't understand why this employer, this county, doesn't want to do things that's considered fair. I'm not talking about, tying your arms or putting chains on you that you can't do what you need to do. The language is there for you to do it. If it doesn't work, take it for a test drive. That's all I ask.
Can I just add, in another sense too, in hopefully being able to challenge the personnel decision as to hire one person over another, to some extent, it can help maintain a little bit of, integrity for public employees and for a public utility to be able to challenge how decisions are made. Because one of the frustrating things is, not just as an employee, but as a taxpayer, when you look at how decisions are made, if there's no way to challenge that or just question it, or a formal way to challenge the process and challenge the decision, then it just doesn't uphold any public integrity at all. Particularly when you do believe that you see things happening that shouldn't be happening. And it may not make sense to, the subordinate employee, but, as a citizen, as a taxpayer, the county should be able to establish, that a process was formed and met.
I have to just,
Number one, we think we have that in place, and we think that the county has been on the path to improving those types of operational considerations. Part of that is by hiring people with more education and more degrees, recent education degrees, that are brought up to speed on those kinds of considerations. So we see the continuum of the county getting better in those operational capacities, not going back to the kinds of things that you've described, but improvements in that regard. So we think solutions are coming in the process that we have. I think for every story that you could tell us, and I'll refer just right now to Barbara and myself, because Barbara's relatively new here, and I come here on occasion, but as you know, I do bargaining and labor work for lots of other government entities around the state. I think for every story you could give us with respect to the downfall or the negative influence of favoritism, we could give you an equal story with respect to the downfall of seniority being a controlling factor in the outcome of what management's able to do, that it's tied management hands in many respects. I could give you hundreds and hundreds of examples of that
I just.
in cases that I've handled over time. All right, so there's no perfect balance between those things. I'm not saying our way is always right, but I think the county, from what I've seen, is on the path to making better decisions about the organization and how it's operated, which I think they would have no trouble standing up in front of the public and defending.
Well, I'm going to, excuse me, when you're saying in front of the public, well, I'd like to see the application that Craig McCandless applied for the job as a utility. Did he actually apply for that position, or was that a position given to him? Because he was the administrator over here in the call center, and at the time when we needed somebody, he was just pulled in over there. So that to me is that person actually applying for that position? I hear so many stories of people being just given positions without even having to apply for them.
Listen, we just need to kind of stay on track here with, I just want to get back to this proposal that I just conveyed. I've never negotiated a provision in a seniority clause that has the subject of G. of G, where, so every single time that you say you have a horror story of how seniority tied the hands of an employer, G trumps that. You're not gonna have a situation where there's some dysfunctional problem that occurred by giving a senior person the rights over someone who was less senior, because you were handcuffed or jammed up or something went backwards, because you can always invoke G. As long as G is legitimate, you got I just.
Yeah, G, the way it's worded.
Right.
Which brings it to finality.
No, not the way it's worded.
Not the way it's- Well, we don't have an agreement on that.
Right, if we could go through we were kind of going through the rest of these, I mean, we heard, we're clearly still at
Do you want
odds.
to agreement, or do you want to reach an agreement, isn't that the goal?
Well, no, I mean,
Yeah.
honestly, I'm kind of not thinking that we're going to be on the same page with seniority. So, I mean, because we're just far apart, our training changes, the first thing I did, the first.
Two paragraphs that would love
No,
most changes.
that's absolutely, it changes the entire nature of the.
Well, you've been somewhat of a disappointment, Barbara, so,
Anybody that didn't give you the seniority you wanted would have been
No,
disappointed, I
actually,
understand
just
that.
based on your comments when you first came here, and the comments that you made in the first part of the session.
Which were, give me a
Well,
list
that
of
you're
those
gonna
things
have
that you'd like
an
to
open
see.
mind, and you know what, you just seem to fall right into the same system, or it was all just a big dog and pony show, I don't know which one it is.
No, I asked you guys right from the start to provide me examples in the departments where you'd like to see changes, and what you told me was that you're not gonna waste your time giving me examples in the departments, you just
I
want a
thought we
blanket
just got through
statement.
listening to an hour of examples.
That was
So,
not an
you know,
example of how you want seniority applied. Nothing seniority-based would have helped the
I
fact
gave
that
you
the
better
degree
than
was
what
not
you
there.
asked for. I gave you the complete total cooperation of working through, I gave you of different solutions, department by department. I gave you examples of
Where is
agreements
that?
we've reached with another county that neighbors this county, which just because you look down on them doesn't mean that they should be looked down upon, that we've been able to work out very reasonable and fair and equitable solutions that they've never challenged in all these years. So I gave you what you asked for. I gave you more than what you asked for. You just don't want to agree because you just don't like seniority. That's what it is. You just don't like seniority.
Our
So, maybe when
Opinions
Ms.
are
Baker moves
hard.
along, maybe her replacement will find somebody that's willing to work with us and the way everyone else in the world does,
Okay.
at least locally.
So, moving onward, we were at 27, and now we're going to 28 on we're getting back into that.
I would, definitely, do it, for sure. No, I'm serious.
29 is a revision of B where their own, the words their own is inserted, replacing people on going as after their own words into that might change.
And that was already TA the last.
This is all.
Yep. Well, yeah, these were the ones that were.
I don't know about the tax, I'm just telling you what today's date is on.
Okay. 30, I had as one that we've already done before. Court leave.
Article 30, court leave, Article 31, conference and educational leave, Article 32, military leave, and Article 33, examination leave, will all agree to be satisfactory.
Correct.
Article 34, what I'm saying is to move,
Yeah, it was just instead of moving the person to a different position, it's the ability to put them light duty at the 80% pursuant to statute, but keep their, benefits in the same position, so they wouldn't lose the seniority.
if that's Florida state statute, and it doesn't need to be It's already captured in the first, the existing language.
No, I disagree because the county will maintain the status quo with respect to compensable benefits. This could alter the status quo. So I disagree that that already exists in the statute because it could potentially affect that. So I don't
Well,
want.
then we're not interested in losing any of our compensable benefits, if that's what the goal is. Is that what the goal is?
No. What the
Well,
goal
then
is
What would be
to,
wrong with keeping the status quo language, which I would like to add, is we've already TA'd on 916.
because it gives us greater flexibility and the employee greater flexibility too, to be able to keep their current assignment but at a light duty instead of making you move them into a different position.
But that's already wrapped in the 440. It's 440.15, correct? And according to your citing what statute it falls under, if the first sentence says, everything is covered by 440, you're going to maintain the status quo. And so you have to be in compliance with state statutes. We don't need to start writing state statutes into the CBA where it's not needed. And the current language is already been TA'd on 916, should just be fine.
No, because the
Unless you
state
have-
the state statute allows us to not pay you for the first 7 days. So if you want to just put in here, we'll abide by the state statute, you'll do that.
Right now, you pay the first 7 days
That's
because
right.
of this language.
That's correct.
We have status quo.
So therefore, that's adverse to the state statute. And that's what I'm telling you. We don't go by the state statute, our benefits are richer than that. My intention
Right,
is.
right, our provision is greater than that.
Okay, we'll just move it and need not resolve that.
You're gonna be in a habit of items that have already been TA'd, you're gonna just start rewriting and changing and then not on the TA. Is that gonna be explained?
Have I done that a lot?
A couple times already?
No, I don't think I have to.
Well, this article we just talked about. TA.
Yeah.
Well, so
Which-
TA
From the
Article
very
20,
start,
and
from
you
the
wanted,
first
you
time.
wanted to make changes to Article 20 from what was TA. You didn't TA, your attorney did.
35 is,
Sort of the word 100%.
100%. They all, that's.
yeah, and that already
Good
existed in
job.
the contract too, by the way, so.
You said 20.
Huh? But yeah, it actually is already in Article 25, so,
Article 25?
yeah.
What is it, 25?
Well, yeah, I know you agreed to it, but I wanted to just point out that it was already in the contract.
What is?
Annual leave where it says planned versus unplanned. It
Article
says,
35, leave time excluded, says holiday leave, annual leave, funeral leave, military leave. It doesn't say anything about planned annual leave. And that's what we just agreed to. You know what, I tell you what, we'll just withdraw that.
well, no, you TA'd it, you were okay with it. That's what
Okay,
you
but
just
you
said.
TA things too. You're saying it's somewhere else in the contract.
No, I was just pointing out that it's consistent with the other language in the contract that you've already TA'd. And unplanned annual leave shall not count as overtime hours, so it's, but I'm just telling you that it's already in the contract, so it wasn't an addition, it wasn't anything.
You want it back?
I don't know, my TAs.
Okay.
All right, 36 was already TA'd previously, so I assume that's okay. And 37 and 38.
I'm still looking.
Forty, I think you're just leaving status quo.
Yeah, it's status quo, we're okay with it. to you that,
Yep. And 42. 41, 42, both thing. And 43 is 12.
No, it's all good. It's all good. We're not being asked. We want people to know. It's not, we don't make this shit up. It's really-
43, we agreed to your change. Shall I assume the final?
that's what I'm saying.
It wasn't
passed
such
it.
a but it
We're
was
bringing it
a,
to light as much as we can.
it was
We
what
just
you
gotta
wanted,
keep-
you
I
had
get it.
language.
Just gotta keep pounding. If you're gonna go up,
Right.
Fight your fight.
Yeah, I didn't
You know
ask
what I'm
him for
saying?
his
You know, you just gotta keep pounding.
14, I'm sorry, 44, or T, with the added language in C, 45, there's no change, and
Nice,
status
we
quo.
shouldn't have
Yep,
to.
and that was
They
already
try to
two
make it
years.
easy. We can, there's stuff that can be done, but we.
I didn't have that we had an issue on that.
Yeah, it was
For
just,
cheap,
it was
they
just
use
still
you, and
held
then when
over
they're done
for a
with it,
while,
that's
but,
it. You save them a lot.
yeah, I didn't know if this was going to be tied in with the, anything to do with the monitor, that's what the hang-up was when C says performance evaluation may not be agreed with. Well, first of all, let me just pass over 44 and 45. If performance evaluations cannot be agreed, and now they're tied into raises, then we can't have that. We have to be able to challenge evaluation if it's should be tied into, and that kind of goes back to your wage proposal, where I asked earlier, are we going to have the ability to impact bargain over the, your merit, because if your merit raises are tied into an evaluation, and that evaluation is the same one that's considered the evaluation in Article 46, and we can't agree with it, then basically anybody can just be denied a raise without any kind of recourse. Is that what the,
I think we said earlier, you correctly characterized it as a waiver. So
Right.
if you're not prepared to waive it, it's open issue.
Well, I'm not sure, I've never seen anything where you're able to grieve on a fully performance evaluation. I mean, I don't.
well, if it's tied into raises, then it's common. Because when you just having a performance evaluation, so you could be moving a little bit quicker, or, pick it up a little bit. Okay, I disagree with you, I'll file a letter of protest. But when you say, you know what, you're not moving as quick as you could, I'm only gonna give you a 0.5% raise instead of a 3% like everybody else, then that crosses the line into a different scenario. And we just can't accept anybody's interpretation of grading or rating someone's performance and then not having a monetary equivalent to it, because it just creates problems, and not having the ability to agree with it. So I guess that stays open now.
All the time.
I don't know what the work schedule, I know we don't have a lot of time talking about that. Well, the last thing I thought we were okay with it because the transit department was a big concern. And I think Jim, you were telling us that, you guys don't necessarily want to be forced to take breaks and lunches.
Well, we don't want split shifts. No Joe's done, so we still at work on it.
Okay.
So you wanna leave it open, or are you okay with the way that it is, but?
I thought Jimmy said you still want to talk about it, right? There's a concern of working split shifts.
Well,
Is there something in here that prevents split shifts?
well, it just says that, it says employees and field workers, with the exception of public transportation, may be granted 2 15-minute breaks.
Well, you're talking about lunch and breaks, but I think we're talking more about hours of work.
Schedules.
Yeah, scheduled are, I don't know, I've never heard any discussion about split shifts, so.
Well, that was the only way they could have figured they could give in the breaks or something.
Right.
And Joe DeGeorge has resigned, and Mr. Mataco will feel about it a little bit, and if we want to discuss it.
We'll leave it open if you want to talk about it, I just don't know what you're.
Compensatory time, we've already, paid.
49 is status quo, but.
I had left it open, but you know what, we'll just go ahead to status quo for 49, so someone will be cut. Outside employment, Article 50 is fine, status quo.
Yep. And 51 as well, I think.
Just see me right at 15 on any of these things, correct me. Oh, we're going to the chart, so we're going to put the chart in.
No, no chart.
I think we're still working on this, right? I mean, I don't know what's in here that's different, but, did you rework this thing?
Yeah, I reworked it, I think now it just, probably, even though the language, I wouldn't describe it as status quo language, I don't know that anything in this language changes the current practice. So I think it clarifies some things that may have been questionable, but I think that this is what is happening at this point, at least it's what's supposed to be happening. So I'll let you review it and tell me, I don't think there's any, not trying to hide the ball or anything, I think this is what's going on, so.
All right, 1, 2, 3, 4, 5, 6 paragraph holiday work.
Yeah.
The last sentence, in the case where an employee works on a holiday, either the holiday pay or the actual hours worked, whichever is greater, will apply toward the calculation of overtime.
Right.
Not both. Do you agree that the hours worked on a holiday, the hours of a holiday that aren't worked also count toward overtime?
Yes,
Okay, so that's the status quo now.
yes, correct,
That's what's in the
That's in the
Right.
lead time excluded.
correct.
right.
All right, I'm just gonna give this a look-see,
Yeah.
but, you know, just so I want to.
I think at this particular time, don't we enjoy both? If I work a holiday, I get the holiday pay at time and a half and another day off. Kevin, isn't that in the it's in the career service manual that explain that way, and they've been doing it for years.
I'd have to read the language and see. I remember something generally from that, but I don't know what's been happening in the departments lately.
Okay, but that's, in my department, that's what they're doing.
Well,
They've been
but
doing it for years now.
Shouldn't, I mean, you should, if you work the holiday, you should get the holiday pay and time and a half.
No, we get time and a half, if we go out and work the holiday, I work 4 hours.
Right.
I get time and a half at 4 hours, then I get another 4 hours off to make up the 8 hours.
But you don't get paid an additional 4 hours of holiday pay.
Right.
So
I
like,
get my standard pay, yes.
you get your regular rate of pay
Yes.
and time and a half and the additional hours off?
No.
Right, that's what I,
I get time, if I work a 4 hour shift and an 8 hour holiday, my 4 hours are at time and a half that I go out. Then I get the additional 4 hours for the rest of the day off at my normal pay.
Right. That's correct. That's it. Yeah. That's what this says.
Okay.
When it's being viewed that way, Doug, and I just want to clarify that I'm right. When a holiday comes, you get your regular 8 hours a day, that's in the bank, straight time, 8 hours a day,
I get the holiday pay.
which is your holiday.
Yes, sir.
Right.
Now, when you come to work and work 4 hours at the rate of time and 1/2, you're getting 4 hours of time and 1/2, and you're
Yes.
getting your 8 hours of straight time. You're not getting anything else for that extra 4 hours that you didn't work. Are you, or are you?
No, for the 4 hours I did work, I received time and a half and the additional 4 hours off because I had to come in on my holiday. But that's straight time.
So you're going home in 4 hours and you're still getting a balance of your shifts?
Yes.
So that's like,
Off.
I don't see
Yes,
that in
well,
there.
yes,
I
she's
think
correct.
it's the same day.
Yes.
It's on that day, what he stopped talking about, not on a different day. So it's just time and a half for all hours worked on that day. This is nothing different from that.
that's not what he's saying, though.
Well,
He's
I
saying,
can't
he's
really
saying
tell what
over and
he's
above your 8 hours of holiday pay, over and above that, he's kind of describing a guarantee for coming to work on a holiday. You got a guarantee of premium pay for the hours you work and straight time for the balance of the shift that you don't work. Over and above, that's what you're describing, right? Okay, I haven't heard of that one, and that's,
Yeah, it's no, it's the same. Yeah, it's just that the career service manual is time and a half plus the.
There's no language about an additional
Right.
additional time off.
like I said, I want to take a look at it.
Yeah, that's fine.
It sucks, don't it,
53,
Frank?
we already went over.
It does.
So-
I'm glad you did that.
All right.
Properties,
TAs, Oh, I'm sorry, yeah, we had more after that, sorry, 54, I apologize, I'm jumping ahead. So 54, 55. Everything else, I don't have anything else open, so 54, 55. Oh, okay, I have, status quo on that one. So unless it's open, I didn't.
All right, my 54 is a jumbled mess.
Well, that's what we're looking for. We may not get everything we want, but if we can stir the pot, sometimes that'll tell you that's enough to get the ball rolling.
If the county requires employees to wear uniforms.
Now, I'm getting trying to make every Greek.
All right. Here's that
Makes
one.
you want to hurt somebody.
There's 55 as well, so there's 54, 55.
Not a shame. I mean, it's a disgrace. It's not a shame, it's a disgrace. That's why I said, you know, I never really was involved on it. That's why we got involved in it. There's so much bullshit.
Yeah, but we haven't done 56 yet, so let's get 56 before we, that's 57. Get on to that. 54, we've got 55.
Position classification.
Right, so I don't have any changes to that, so it's just status quo on this one.
Yeah, we'll just get that out of the way. I mean, we were gonna hold off on that to,
You have
but it
it or
might
you
possibly have an impact on, our seniority provision, but even with our raise for, you got status quo or something.
I need to keep that. Oh, you've already signed that.
I did.
Oh, no. Oh, wait a second.
He was
Oh,
signing. the
sorry,
same
okay,
one I was
got it,
signing.
okay.
I didn't,
Sorry,
yeah.
sorry, sorry, yep. Okay, got it. Now I understand. All right, so, all right, that's his
You got
copy
that?
back. Yeah, that's
57.
nice. Is that ours or wait? Oh, no, I'm sorry, that's mine.
Yeah.
That's yours.
Okay, 57?
Is there 56 in that pile of signs on both of us?
Yeah. Yes. I don't know what happened.
57.
Yeah, me. All right, 57.
58, we're gonna declare and pass over. Just kidding.
Agreement.
We're gonna hold off on 60. Liquidation only because, you know, we're going to do chicken roll and all. If I stick my committee for lunch on a third time, I'm gonna go out.
Oh, you're damn right about that, brother.
I keep having them make copies of all these.
Is bargaining over, Jim?
No, just for the
Okay.
purposes of clarification, right, just flip over these and give me the articles that are open.
Open?
One for you.
I have
Okay,
here.
let's go.
Here's the open ones. I just kept it as a.
Oh, yeah, okay.
Yeah.
So, what remains open
No, I don't know. Just don't,
is
you know,
Article
just don't let it
3,
turn around and then-
just cause discipline. Article 16, union stewards. Article 17, union leave account. Article 18, probationary employees. Article 19, contract negotiations. Article 20, grievance and arbitration procedure. Article 21, seniority. Article 23, safety committee. 34.
What's the deal with the safety committee? It's not open, it's just so you're gonna clean it up.
We need to clean it up, so we have
Yeah,
a
so
TA,
it's
so
open.
it's open. I'll fix this, but.
Article 34, workers' compensation.
Hang on a minute, hold on, catch up.
39, promotions and vacancies. 46, employee performance evaluation. 47, work schedule. 52, holidays. 53, wages and salary, or whatever it's called. Doesn't have anything to do with it. Got cut off.
Oh,
And 60, duration. Do you agree?
Yeah.
Anything else you think is open?
I don't believe anything else is open.
All right.
I'm just asking you a question. DOT medical certificates. That's probably been called over by Bill T and stuff. They get those certificates back and then the drivers.
We were gonna bring that up after negotiations. I got a couple of things to try to avoid a few grievances, if that's okay to discuss with you.
I'll
After.
defer to them, whatever, but we can talk. I know there's an issue with those medical certificates and the waivers that they file with DOT for their license. That's been handled internally in PCDP.
Yeah, as far as the medical cards go, there's been a couple of incidents, and there's actually one right here. The form was incomplete.
Are we done bargaining, because we're
Yeah.
recording, there's no need to
Yeah, you-
record this,
yeah,
right?
You don't have to.
Okay, so we're wrapping it
Make
up
copies and bring them back down.
at 1:10.
Yeah, I'll either listen to him or make the copies, but I can't do both.
Can't walk into
Well-
them.
I can't rub my stomach and pat my head at the same
What's
time
the
either.
So that sounds personal.
Well, the issue is
TM.
a law change in 2015 that, like, this was the old way, the county had it, if you were a government employee, you could be exempted from carrying a card. Now, since 2015, the laws have changed statewide, different states. I was in Texas in November, and of course, we know about her incompleted medical form, Sandra Johnson. Okay, that issue, if you had it, should have resolved that at the end. The other issue is different states have different guidelines. If you have a CDL, like going through the Border Patrol checkpoint, they don't screen everybody, but they'll do a few: license, registration, insurance card. If you have a CDL, I need to see your current medical certificate. Well, I don't have it, well, why not? You know what I mean? We require it in Texas, we don't care what Florida does, you got a CDL, we don't know if you're down here, drove a truck, and now you're in your Cadillac. But it's probable cause for, if we ask you for that, you don't have it, we can search your vehicle, truck, car, whatever. Okay, same thing in New York. One of my drivers was up there on vacation, a roadblock in New York, state troopers, just for DUI check, license, registration, insurance. So you have a CDL, you can see your current medical certificate. Well, I don't have it. Why not? We don't care how they do it in Florida. You're supposed to have it, you have a CDL. You know, so my thing is can we get those cards back to all the CDL drivers? I know
They
that
should have a copy of their own card, right?
we don't have.
It's not a
it.
card, it's just it's a form the doctor signs
Yeah,
off
it's-
Oh,
at the medical center.
Okay.
They just send it over, we
there
file
was
it.
a card too. that
There
they
used to be.
driver's-
Yeah.
They used to, but I guess they don't
It's actually-
require them, they
Well,
haven't been
it-
required here.
Because we don't require the cards, but what they're saying is if they do require them to go out of state and drive, then you have to
Or if
have it.
they're even traveling and there's a checkpoint, they
Yeah.
just see CDL on it, they wanna see their
And that-
medical card.
Yeah,
And
that's kind of a personal thing though, I mean, it's not
And what
a,
Jim
This-
was gonna go into further, one of the ladies got her license suspended.
Yeah.
Which
Well,
had to
she-
come back
We
and
know
go.
about that, she
Yeah.
got a
Oh.
letter that she didn't open for 2 weeks, just so you
Oh,
know.
okay.
I have some
They
mail
are.
like that too. The thing was, when the doctor sent it back, it was incompleted. So then, here's her medical certificate, he signed that. That's the card we need to have.
That piece of paper right there is what you
Yeah.
carry, not a special
Well,
little
it's
card that.
you have the original on the hard form that he sends you back.
It's a copy, they fax it, but it's just like that.
You should have the copy, they should have the original, because the troopers are gonna tell you, the copy don't count. Your employer should have that. You should have the hard copy that was on the form. But then on the other one, and then this is all the laws and stuff on it. This was the one that came back incomplete. Because of no fault of her own, I guess you paid her for all her time off. That's what she told me. This is the part, though, she got fined for not having the card. I still think the county should pay her $82. It was no fault of her own. She thought it was already good because you had the paperwork here on file.
Except it, and I follow you on that a little bit, but
Yeah.
I will just say the one point that was leaning not in her favor was that she even admitted that she had a letter that sat in her mailbox and she doodled on and kept it on her table for a while and did not open it, and it told her her license was going to be suspended in a month if she did not renew her waiver.
Yeah, I have the whole packet here, even her handwritten letter I retyped out. I mean, we're welcome to have a copy if you want to go over it.
You know, certainly I'm open to working with the department, but
I just would like to see, everybody has a CDL in the county, have that card with them to avoid this again.
Well, this is what I'm thinking is a problem, because although transit people may require the card because you fall under a different division of FDOT, fleet guys, and quite frankly, any public works facilities
They
guys
don't.
do not require the card, so that's why it's pretty stunning to me that it's.
I haven't got pulled over out of state
Well, that's what I'm
luckily, so
saying.
I really don't
But,
know.
I can tell you, like, the road and bridge guys, they do the waiver.
I mean, if,
Right, they have the waiver.
They have
so
the
they don't
waiver.
have
if,
the-
if you'd like, I can go speeding through Georgia like 75 miles an hour and have that guy with the big Smokey the Bear hat come out and say, "Boy,
Give us a call.
why are you going so fast, boy?"
So you gotta call my
Give
attorney.
us a call.
Yeah, call my attorney, get your shit off.
We'll try to raise bail.
Yeah, we got time
Oh,
for
really?
8?
If I
Yeah.
don't get back to you in a couple of weeks,
Old, beat up.
No problem.